now. Yeah.
There we go. Hello, everyone. I guess we're going to have a very fun and light session today on Quebec Loi 25, if that's ever possible. Yeah, so comment ça va? That's what we want to know. How's it going? Comme ci, comme ci, comme ci, comme ça, like the song says. So today we have us on the panel, and you've seen this slide. I hope you're not reading everything. So myself, Carlos, who's with EY, and Constantine, who's with Novation, and he's been in privacy for a very long time, and he's on the legal side. Carlos is going to be more from the kind of what are some organizations that are working with UI doing, and I'm on the side of some practical advice in some smaller organizations that I've been working with. So I think we're covering all the bases here. All right, so let me move to the next slide. I think we're just going to go straight into it. Today, the point is to understand how prepared organizations are, where they're stuck, and how we can help, right? Constantine, you want to run us through who is caught by Law 25?
Well, in some ways, it's not terribly different if you've had to deal with GDPR or even PIPEDA's application outside of Canada. Really, it's fairly broad. I mean, it's not defined in Law 25 itself, so you have to go to the civil code in Quebec to understand how there is going to be a real and substantial connection. And what you see on the slide is some examples of what that would be like. But if you are selling actively to Quebec residents, even though you may not have a physical presence there, then you're going to be caught by Law 25. In dealing with the similar questions from companies that are concerned about GDPR, was saying, well, how do I avoid being caught by this law? You would actually have to take some fairly clear steps, like on your website saying this is not intended for residents of Quebec. But more than that, you'd actually have to take some positive steps to make sure that if you're, say, for instance, a retailer, that you're not going to take money from people in Quebec. You'd have to actually be able to, it's not enough to simply sidestep it by saying it's not intended for and still take orders from people. And of course, if somebody uses a VPN to get around this, okay, well, you've done what was reasonable to, make sure that you're not actually, doing business with Quebec residents. So it does require some positive steps. The question, of course, I would ask any company, if they were talking about doing this with Europe or with Quebec, is why would you walk away from that market?
Even if you have, yeah, exactly. And even if you have, so I see it as to a two-prong. If you have customers in Quebec or employees in Quebec, sometimes you don't have customers in Quebec, but you have employees in Quebec.
Exactly. And that's what's important, is that Quebec's law is like GDPR in that it covers both sides, the consumer as well as the employee. And so this is also of criticality. What is important, though, to distinguish, I think, is because this question's come up. What if I, am using a logistics company based in Quebec to do delivery? Well, you don't have employees in that case, right?
Yeah.
But I mean, we'll get into what kind of information you might be receiving from customers in Quebec who might be, say, for instance, business contact information or employee contact information. You're still going to have to do some things in relation to management of that data, but we'll get to that.
Right.
I'm sorry, something I want to say on the previous one, Amalia and Constantine, because I have seen this with different organizations. I want to talk about volume, and I will call volume because there are some companies that say, well, we do have some operation in Quebec, but it's like 10% of the operation or 5% of the operation. We have very few employees, or we have a couple of clients. And because of that, I have seen companies that are not paying attention at all to the regulation because of the volume. But I want to call that out because I think that volume can be somehow relevant from the risk management perspective, because of course the risk of exposure will be reduced because you have just a small portion of customers or employees in that jurisdiction. but that does not mean that you don't have to comply with the regulation. So,
Yes.
so you need to pay attention to that, because even those 2 employees or those 5 clients can unfortunately be the trigger to something that can end up in a significant fine. So,
Yes.
so I think that it is important for companies to pay attention to this. And I think it is important, of course, to understand within the entire operational model the company has, how is it that that specific component they have on employees or customers is going to be representing something for them. So in alignment to everything that was said, it doesn't
Yes.
matter how large the presence in
Yes.
Quebec is. If there's
Right.
presence, then you need to pay attention to this regulation.
That's a very US view as to the percentages, how percentage of business you're doing.
That is quite correct. I mean, Canada and Europe tend to be like, it's one law for all organizations. And as Carlos said, risk is really where you see that variation come in depending on size and numbers. But the US has a tendency to carve out, like thresholds to avoid impacting small businesses. And we just don't do that here.
Right. That's a
So it's
very
not
important
relevant.
distinction. Yeah.
Not
Yeah.
relevant for the assessment of whether you're caught by it, but like Carlos said,
Yeah.
it may impact what you have to do.
Yeah,
Right.
which means that compliance with the regulation, regardless of the size of your operations in Quebec, needs to be inserted or embedded in the larger risk management picture, so that you can have
And
this
we will
properly
definitely
inserted
come,
on that.
and
Yeah,
we will
yeah,
definitely come back to that.
perfect.
Yeah.
Sounds
Yeah.
good.
So moving on, I think after we understand if the scope of application, the next thing in organizations that we do is, okay, well, we have to say what we're doing. And, again, Constantine, maybe you can lead us into this consent and notice discussion.
Well, and I think that, there is, of course, the need to be clear and simple. And when we talk about, clear and simple language and understandability, you always remember this has to be en français. I'm the worst one to actually say this because my French is so terrible. However,
You're not alone.
you've got to make sure that this is clear and simple in the French language. So this is not something to underestimate in terms of effort, but clear and simple language. You've got to be clear about what you're doing with the information, what you're, how, the rights of the individual, because personal information can only be used with consent. And it can be expressed or implied, but it has to be expressed if it's sensitive. So you've got to be, and it's got to be free and informed. It's separate from other communications, meaning you can't mix it into some longer agreement or consent that's that you're melding different kinds of agreement with. It's got to be called out separately, and that I think is really, where most organizations are going to be facing a challenge because number one, there's UI developers and people on websites, develop websites don't want to have road bumps, like separate checkboxes for things. But this really is not something that's avoidable in my view, because that clarity and that express consent has got to be obtained before you actually collect information. And that before part is really quite critical when you think about it, because, in many cases, websites are beginning to capture information through cookies and web beacons well before the individual is aware.
Right.
So think
Right.
about that from the point of view of, again, timing. You've got to make sure you've got that consent before you actually start collecting information.
Right. And to me, there are two aspects that caught my attention. This one, the third bullet, name of third person, persons for whom information is collected. So your third parties. And we want to talk a little bit about that. And also the other point that says you have to make available or name on your privacy notice the policies that you have inside the organization, so to show that you're actually handling personal information with good governance and with good rules.
And that's not something you're going to come up with when the CHI approaches you and says, hey, tell us what your policies are. So, I mean, this does require some advanced work, right? If you're just trying to do this, off the cuff, it's going to be obvious to everyone.
Yeah.
Yeah.
And I want to call again for simplicity. I think that's something that is fundamental. It is pretty common to see privacy notices everywhere that are long, hard to understand, hard to follow, and that's not the purpose of this type of documents. I think that there's many organizations that take, I will say, a very selfish approach on the preparation of privacy notice, because they think of this as an instrument to protect themselves
Yes.
from any action the customer or the employees may be doing, instead of using these for the purpose that it is intended, which is informing individuals how personal information is going to be used and to easily understand how they can interact with the company. So I think that simplicity is something that we need to pay attention to. There's this historic confusion, and please let me know what you think of that, of calling a privacy notice a privacy policy, and then effectively transforming the privacy notice into a privacy policy, which looks more corporate than that vehicle the company needs to communicate how personal information is going to be processed, which I think is a very common situation.
And I'll say the other thing that this is going to probably highlight, I mean, and it's one of the issues I get on a soapbox and scream about, is the tendency of organizations to simply copy the 10 principles out of PIPEDA and call that their privacy notice. Telling us the law is not a privacy notice.
Yeah.
Tell us what you're doing with data.
Right. There's no commitment there.
Right? Yeah, no. And I mean, and I think that, that goes to the heart of what Carlos is talking about. We have to be able to tell people what we're doing with the data. Don't reiterate the law, because that's not telling us how you're using and processing information. So I think this has become quite critical, because as we're going to get into this, Quebec's law is a very consent-heavy law.
Right. So I put together, and I advanced the slide a bit further up because I wanted to explain why this is such a good idea to have a good online privacy notice. And it goes back to our first conversation on, you have to understand what your business is doing, and you have to explain how you're conducting your business. And of course, that is going to allow your peace of mind to your executive team, to your board. Their first objective is to perform. Their first objective is to grow the business, so to execute their strategy. This is one area where they can have peace of mind, is if this online privacy notice as a legally binding document is executed properly, it's written properly. So the other side of the coin is that regulators can ask questions about internal practices. So this is not something, to Constantine's point, that you want to copy from somewhere. You have to give a lot of thought if this represents exactly how you're conducting your operations. And if you're doing it right, you're not going to attract attention, and you're going to have your senior management have peace of mind that you're handling data according to the legal requirements. Any comments, Constantine? Or
it's a very good summary. I think you've also linked important concepts like the corporate governance and the responsibility of the board. Did we mention that the fines under Law 25 are up to 4% of global revenue?
Not yet.
Okay. So, I mean, maybe that should be one of the first things we say, because everything that we're going to talk about now has that consequence of its importance to the organization, because the failure to do these things is going to have significant impact potentially in terms of fines, reputation. And so all of this needs to drive upwards ultimately to corporate governance. Why do we create fines at this level? It's to get the board's attention.
And it's something else, Constantine, that we've talked about before, which is very unique to this law, is that it draws attention to the strategy and why you collect and use all this information. It has to be aligned with your strategy. So that is where I think that is in my opinion, the best way in which accountability has been ever phrased. It's like you have to align your data handling and the operations around the data to match your strategy. you can't have unknowns or, oh, we're doing it because we need to, but we don't really know what's it aligned with.
And another point about accountability we don't really talk about in the presentation is that by default, the CEO is responsible for the privacy program.
Right.
So they can, of course, delegate that job to someone. But I think that also highlights the accountability sort of aspects of it. So when you link it back to, again, what you're telling the world about what you're doing with people's data, you now have to really understand that from a point of view of, I'm accountable to that individual. It's not a policy, as Carlos points out. It's a notice. It's telling people. It's a communication. It's a transparency. But it's also an accountability. It's about explaining to people what you're doing with their data, and that you mean it, and that you're going to comply with the things that you're saying. So, and again, we don't talk about, again, this is the sort of lawyer aspect here, about the risk of litigation. But Quebec has had a greater willingness to certify class actions than the rest of the country.
Mm-hmm.
Maybe bear in mind, that is also going to be a driver for organizations. Maybe if you're having trouble moving this message up the ladder, they don't maybe appreciate the impact of regulation enough. Management tends to get litigation risk. So all of these things are driving, again, a commitment to the individual. What's expressed in the notice has to be an organizational accountability. We got a question. If the default PO is the CEO and delegates it, what authority should the PO have the organization to be effective? Well, that's a very good point.
Excellent question.
And so really, I think that what the law drives for is that you've got to have the ear of the CEO. You've got to have the ear of effectively of management. It can't be relegated to the back office and then ignored.
Yeah, given to an analyst in the lower ranks. Yeah.
And, so that essentially it's giving lip service to the law. So because still, even with that delegation, who's still accountable? The CEO.
Right.
So,
right.
You're not solving the problem. There's no sacrificial lamb. There's no, sort of, way to sort of, push this down the ranks and make this unimportant. It's not allowed. It's just not going to happen.
Which also means that you're going to have to, the CEO needs to understand they're going to have to receive updates about comment ça va. Like, how's it going? How are you implementing this? Where are you at? That's why I think that CEO role was appointed as being accountable, because not responsible, but accountable, because they need to receive updates. It has to be an ongoing monitoring effort on that role's part.
I would actually say that a delegation probably isn't effective if it doesn't give substantial authority to whoever is acting effectively as a privacy officer.
And you know what? I think it is, of course, very important to have these set at the top level within the organization, and understanding that the CEO is the first responsible. That's fine. But in addition to that, I think that it is important for the board of directors to know what to do, what to ask, and what's the behavior they need to have. Something I have found very useful, there's this National Association of Corporate Directors in the States that has been investing time and resources on providing with some guidelines and some leading practices for board members on how is it that they need to behave and what questions they need to ask to validate how effectively cybersecurity is being managed. They have not jumped into the privacy space with that level of detail yet, but I think that many of the recommendations they have for cybersecurity can be easily translated into privacy. And this level of skepticism they need to have, and the clarity that they need to get on how the company is responding to these compliance obligations, is something that is very necessary. Because if the CEO is supportive, but the board is not aware of the fact, and they are not giving the same level of support, we can definitely have an issue. So I would invite companies that are facing that challenge to invest time on educating the board of directors and helping them understand how is it they need to challenge the company on confirming that the company is effectively complying with these regulations.
Yeah, that's
and I'll add to that, Carlos, there's something I've recently joined called the Digital Directors Network. which is actually very much focused on these issues. And again, we don't want to go too far astray because cybersecurity and the new SEC rules about reporting have all driven a much higher degree of awareness. So the Digital Directors Network is another organization that can, again, is trying to drive, let's ask the right questions for management, because that's the role of the directors, is to ask the right questions. And they don't often have the expertise.
They don't have the background. Yeah, that's right. Yeah.
To do that.
All right, so let's jump a little bit into how Law 25 is not GDPR.
Yes. It was interesting that it was originally said to be based on GDPR. And in some ways, I really wish they had done a closer copy, to be honest, because it would have made legitimate interests a thing. And that we are, is really very important in Europe because it's the basis on which most data is being actually processed, not consent. But secondary uses, are permitted under Law 25 as long as they're consistent with the original purpose. What does that mean? That's really going to be the killer question. And so when it's got to be consistent with the original purpose, it means you've got to think through and document carefully that exercise. Is this consistent with the purpose that we originally gathered it? So it's a narrower basis, it would seem, than legitimate interests. And again, it just highlights the importance of consent under this law.
Yeah, and the importance of documenting. So if you think this might be legitimate interest, you have to document the heck out of it, right? Just to make sure that it does read like, yeah, okay, it is legitimate interest. So, and of course, to fit into what the law says about legitimate interest. All right, so we've talked a lot about how others have done it and how others are doing it, but I don't know if at this point, if there's some other examples, or we can come back to this slide and just maybe continue a little bit more on peeling the layers, because I think we've talked quite a bit about some examples. And I think we've talked about this, drafting the notices, right? We talked about the transparency. We talked about, the documentation that you have to say, these are the things that we have in our organization that govern the different requirements, right? But the first point there, Constantine, maybe you can explain that a little bit, the multi-layer notice.
Well, it shouldn't be news that we need to think about multiple layers or structured privacy notices, because one of the things that, of course, we're trying to do is communicate here. This is a fundamental, as Carlos pointed out. Writing it like a corporate policy or like a contract doesn't help in understandability. So now, of course, we do need to have certain language there because this is something that organizations don't want to create liability for themselves. They don't want to give rights of action to people because of misstatements. And bear in mind as well, if you're operating in multiple jurisdictions, like for instance, the US, the FTC holds your feet to the fire about the things you say in your privacy notice. It's a promise to the world. So and the Competition Bureau, to a somewhat lesser extent, has started to go down the path of doing FTC-like kind of analysis with Facebook a couple of years ago. So you do need to make sure that there's language there that addresses the legal sort of issues. But a structured privacy notice is meant to enable a plain English or plain French understanding of what it is you're doing with data, and then structure it appropriate to the purposes, maybe the different business activities that you're involved. Right. When I was at Symantec, we had 5 wholly different families of products. And they were all different and all presented at different times. And I apparently made myself popular by just simply doing one thing, putting it all on one page, having simplifying the language in each one, but of course making them similar, even though they were for different products. And then at the very middle, here is the summary. So that's a structured notice. I was really stunned when I was showing this to people to see that there had been 25,000 likes of my privacy notice. Who likes a privacy notice? I've never liked a privacy notice in my life.
I only like the funny ones.
Well, you know, I try to work in some things sometimes, but I know when I have to stop. But again, you know, just by virtue of doing, and one thing that might be a great little piece of advice, the one thing that got the most complaints when I was at Semantic was, how do I unsubscribe?
Mm-hmm.
I put a big button in the middle of the page that said unsubscribe here.
Because that is the right way to do it, right? The all these little hidden ways to do it, those are deceptive.
Right. So think about what complaints or issues you've had with people and preempt it.
Yeah.
You know, give them what they're looking for, what they need. You know, that's a way that to use a structured notice in a privacy page to reduce people's angst and frustration. Because why are they coming to the privacy page in the first place? Because they have a problem.
They have a problem. They wouldn't read it otherwise. And I think by this similarly, the consent language has to be, again, like you said here, it has to be valid. It has to be easy to understand, but it also has to properly explain everything because then you're getting to oh, but I can't do this because I didn't obtain consent. I'm going to have to go again, get consent. I might not get it. Now I can't use the data. I have to anonymize it, so it's not usable. And I think that's where people are a little bit, I think, scared of consent. But if you use the proper language and you explain exactly what you're going to do, and it is a consistent purpose, I think you're going to be okay.
And the other thing to bear in mind is notice is not just on the privacy page. It's wherever you're gathering information. That just-in-time notice has to equally be understandable, clear, directed to the thing that you're doing right then and there. And it's really a good strategy when you think about it, because you're doing it at the point of collection. You're adverting directly to what it is you're going to be doing. It's very, again, think of it from the point of view of the regulator looking over your shoulder. If you've asked cleanly and plainly for what's needed for that particular situation, then you're going to be in a much better position regarding how you're going to be able to defend the things you do with the data later.
Right. And similarly, think if the data subject came to you and said, you know, show me what you're using my data for. Well, you can go back to the consents and go, well, you've consented about this.
Oh,
this is
and
what
that
I'm doing.
I think is the really important. I think we get to that in another slide, but this is a record-keeping exercise, guys.
Right.
This is not about just, you know, like presenting it. You've got to actually be able to refer back
demonstrate,
to the you've obtained, right?
Yeah.
So,
Konstantin, Amalia, sorry, we got a question from Shazin.
Yes.
And I think we have already replied to it through the comments you just presented. Shazin was asking, can you talk about where consent placement would be the best practice under Law 25, maybe at the point of collection, which is practically what you were saying, Konstantin, that you need to be upfront where data is being collected in order to let people know why this data is being collected for. And how it is going to be processed. Shazin, I just want to make a pause here. Is this responding to your question, or do you still need something that you want to discuss with the team here?
Cool. I think we're good.
Perfect. I think Shazin is fine. Perfect. Thank you. Yeah, sorry.
Thank you. So let's move to some practical challenges. Which one do you want to pick on, Carlos?
That's a good question. I think I can talk about privacy by design, and I can talk about employee awareness very quickly. On the privacy by design side, I think the concept is cool, and of course perhaps one of the favorites. But I think that when you are doing this integration of privacy controls, I think it is useful to think of the ultimate outcome. What is it that you want to achieve in the end by doing this? Of course, privacy is one of those components. But I am thinking beyond privacy, and I think that what everyone is trying to create and preserve today is trust. So when it comes to privacy by design, I would encourage people to think not only of privacy, but trust. So how is it that the processes we are going to be running, how is it that the applications we are going to be using, how is it that all of these elements connected will help me create trust with the multiple stakeholders I am interacting with, or preserve the trust that I have already created, which I think goes a little bit beyond privacy. And now with the interjection of artificial intelligence and all of those components, I think it is indispensable to think beyond that in order to make up these models something effective. Let me just jump very quickly to employee awareness and training, and then I will go back to you, Amalia. I think that we need to find a way to make this effective and fun. I think that everyone is tired now of receiving tons and tons and tons of emails. And I think that using the traditional ways for that is complicated. And it is challenging because I think there's no silver bullet answer for this. And I think that every single company will have different culture that will be open to different ways of thinking. I remember that one of my clients, the CISO, had an idea that made me laugh out loud because she was in the process of helping people understand phishing. So in order for that to be effective, she got a costume of a fish. And she was just going to the offices dressed as a fish.
As a fish, trying
in
to
order
steal
to
their
explain
papers.
exactly things and phishing. So that was insanely funny for that company, and it worked. It may be a completely absurd idea for a company that has a different culture, that can be more conservative and perhaps more formal, but it worked perfectly well for her. So I think that devoting time to partner with human resources and communications, perhaps marketing, to understand what's the most effective vehicle to make up this something that is attractive and fun and engaging is fundamental for it to work.
Yeah, that's such a great example. I wanted to just quickly add, as I have painfully worked through this privacy by default consideration, to say you can't have privacy by default if you don't do privacy by design. Like if you don't really get down to understanding what privacy by design is, what needs to be by default, those privacy settings, you're not going to be able to just jump into the middle of product development and go, here, I'm going to put privacy by default. You really need to understand the use case and to understand how, to me, this is the other side of the coin of reasonable expectation of privacy. Like what's reasonable to an individual and what have you said on your privacy notice? I'm going back to that. Constantine, what are your thoughts? We haven't talked about cross-border, so it's yours. It's free.
Well, I mean, so cross-border, I think, is going to be very challenging for most, especially smaller organizations, because you've got to try to assess the risk associated with taking the data somewhere not Quebec. Okay. It would be really lovely if they would whitelist the other provinces in Canada so that, again, smaller organizations don't have to go undertake, because I've done a number of transfer impact assessments for companies based in the US who are required to do that because of the Schrems II decision, which I'm sure all of you know and love. And, accompanying any data transfer from the EU, you now have to think about what is the risk associated with, for instance, law enforcement getting access to the information. And you've got to document this. That's a big lift for most smaller organizations. They don't have the resources to be able to actually do that kind of an assessment. And so, especially when you're talking about vendors, who are your cloud vendors? Well, they're probably principally based in the US. So now you've got this additional sort of element of doing there's multiple PIA requirements. And one of the key ones is if you're taking the data of Quebec residents out of Quebec.
And put in the cloud in the US.
And and you may not even be consciously aware that you're doing that. When you're using, Google Cloud, Azure, AWS,
Amazon,
what you're doing. Now, the good news is those guys are mature enough to provide information for GDPR purposes that probably in most cases will suffice. You'll get a SOC 2, you'll have all sorts of assurances. You can do a reasonable job based on the information they're providing because they've already done this with GDPR. What I will complain about is having done this now with some Canadian vendors, trying to do the same thing for Quebec has been problematic because they don't understand the importance. They're not providing the same level of information. And it is almost impossible to conduct a PIA without input from your vendor.
That's right. Yeah.
And so the obligation is on you because it's your customers, your employees' data, but you're trying to extract information from an unwilling vendor.
Right.
Unwilling or unable or incompetent or I don't know what the right word is.
Yeah, whereas with GDPR, I've seen many new vendors like startups, and they actually have, and I've recommended to them, do a PIA, put a PIA report on your website in one of the pages to explain that you've gone over, you've done this, and you've assessed whoever your partners are, and they are indeed aligned with GDPR. I think that concept hasn't hit some of the vendors in Quebec themselves.
Possibly. I mean, this is essentially a big part of the issue. I mean, and one of the reasons I'd wish that they'd, copied GDPR, frankly, is that it would have made the case to a vendor easier to say, well, you're doing this not just for Quebec, but you'd have to do this for any client based in the
Exactly. Exactly. All right.
So
So in the interest of time, let me move to challenges 2. We've talked about documentation, right? What haven't we talked about in here?
Testing your notice with your customer base. I mean, I think it goes to Carlos' point earlier. It's like, why are we afraid to ask people?
Yeah.
Isn't that what marketing departments are for, right? And like, let's maybe actually ask them, do you understand this? Does it make you feel creepy if if you can't get past that creepiness test, maybe you should rethink what you're doing with your data?
Yeah.
Just a thought, because and I'll say even more broadly, when you think about the PIA, since we were just talking about PIAs, don't regard, like, most PIAs are a bunch of us sitting around in a room. It's an echo chamber, right? It's all everybody is working for the same company, and we're working towards, and we all understand what it is we're trying to do. But does it make sense to somebody who would be sitting outside? Your consumers.
Exactly.
So maybe ask.
One of the things that I do, actually, I take the privacy notice on the website when it's in a final state and we're like, okay, we're happy with this. And I actually go to different departments and I go, okay, well, let's read this together. So you tell me if you understand what your obligations are. So I'm just putting them, behind the mirror. Go, okay, do you understand when we're saying this paragraph, what that means for you, what you should be doing internally, right? Because I think that's where Carlos was saying it's fun to do training fun. I think it also has to be relevant, as much as this is a lot of legal stuff, but people inside organizations need to understand it in simple language. Oh, and now we're going to my favorite topic. Not exactly. It's
Amalia, sorry, before going to anonymization, something that I want to stress is the relevance on identifying third parties. As we had on the previous slide, there's many cases where serious challenges, complicated situations that companies go through are related precisely to having third parties not properly paying attention to privacy considerations. We need to keep in mind that we are going to be as strong as every single node within our extended enterprise is. If we have a vendor that is not doing their part and they are keeping a portion of the personal information processing activities that we are responsible for, that can compromise the entire thing. So we need to pay attention to that in order to make it work properly. And I also have some other considerations to say about what others are doing, but we can revisit that in the end. That's all I wanted to say about third parties. Thank you.
Yeah, no, we will do more in the end because we have a slide that says, what can I do to be ready? All right, so walk us through this, Constantine, if you can. Bill C-27 versus Law 25 anonymization. There's a higher standard, right, for anonymization in Law 25.
Somewhat. I think that the good thing is we get into the regulation that's being drafted is it still references best practices, thank goodness, because we don't really, that is something that's going to alter over time based on technology and risks. And I'll say honestly, I'm not sure it's at this point if C-27 is going to happen, because there's very limited time before Parliament breaks for summer.
Right.
So I would say, however, really focus on understanding what the requirements are in the regulation, which we're going to come to, because that's the practical guidance. Now, I think that the thing that's interesting both about C-27 and Law 25 is the prohibition against re-identification, against undoing this. And this applies not only to the company that might be doing that, but if someone else, basically circumvents this, that they're liable to, quasi-criminal sanctions. So that having been said, I think that there is not a bad alignment between C-27 and Law 25, which is what this is really intended to sort of, highlight. And I think that the devil's in the details. It's what are you going to rely on? And when we go to the draft, we may as well go on to the next. Yes, because it's no longer draft. It was drafted in January. It's now effective May 30th.
Yeah, it's as of last week. It's no longer draft. So
yeah, and it's now going to be
go.
effective. And I think that one of the key sort of concepts is under competent supervision, that an expert has to actually weigh in, which is good because if, many of us who dealt with organizations on this level have realized that somebody removing the name and the address thinks that's anonymization. Well, it ain't really. There's no sort of real discipline around it. What's been called anonymization in the past, really, if you're doing an assessment of a vendor, you've got to ask them, what do you mean by that? Because it's going to have to now, live with this regulation. And many times people have had this mistaken notion that just by removing a couple of key data elements, they think that they've done it.
It's a common mistake or misalignment of definitions with the US. For US, anonymization is actually pseudonymization, which is what you're talking about.
And that comes really from HIPAA, which said, if you take these 19 elements out, then you've done it.
Yeah.
Or you can get an expert opinion. Yeah. Most everybody since the 90s has recognized that removing those 19 elements was not effective. They could easily re-identify the data. So it's a safe harbor approach, but it's not been an effective one. What's really more important today is that expert opinion.
Yeah. And let's not forget, anonymization done right requires a lot of technical expertise and tools that you can't do it. And I wanted to skip this a little bit and we'll come back to privacy impact assessments to give you a quick sense of some very, very smart people from the province of Quebec, from Galling, the law firm, Justin, and actually Antoine Guillemin, who was not in the presentation, but was part of putting together this presentation. It was all in French. So they've actually done a little demonstration of how you need to think through, well, first of all, the steps presented in the regulation, which is identify, engage specialists in anonymization, establish the purpose. Sounds a little bit like AI, remove personal identifiers at risk, pre-test, select the techniques for anonymization, retest to see if you can re-identify. But what caught my eye really was the example, right? So what does it mean to end up in an anonymized context? You take the name out and you do not point it out. You take the address out, you don't point it out. You take the email out, you don't point it out. So they've explained really nicely what the K anonymity technique is. And K stands for as many layers that you can remove of these identifiers, the better your anonymization goes. So you have the attributes that identify you that you can remove, your name, your gender, postal code, date of birth, and let's say total amounts of payments, lots of information that can make you identifiable. It was found that at least one level, it'll be an individual that have the same quasi-identification attributes, and that the risk of re-identification is 1 over that how many identification attributes, so 1 over K if you're doing 3, 4, 5, and so on. So this is an example that shows that 2 people could have the same quasi identifiers. And then the next example shows you the different types of identifiers you should focus on. Identifying attributes like OHIP number, case file, quasi-identifying, which is your gender, sex, date of birth, postal code, language, and then sensitive identifiers. And it kind of shows you how diversity in your set allows you to use k-anonymity to work with diversity to make things less and less and less identifiable. The risk is lowering. This is a 5 anonymity to diversity implementation. I think this is, to me, like the easiest way to understand, and it's not easy. But when you have 5 different elements, and then you have the diversity of male, female, then you're getting into a much more, I guess, a stronger way of anonymizing. But this is something that I think anyone in an organization can think through. It's not to the level, the complicated level of mathematics that can go into an anonymization technique. But this is an interesting example that can help your developers to think through, well, what can I do to hide this person in a group, right? So I just wanted to give you guys like the 2-minute run through, and then we can go back to, I don't know if there's nothing more. Let's go back a little bit to the PIAs. But I wanted to thank the Gowlings people that were really, really good with their presentation.
And I think that the way to tie that together with the PIA stuff is to say, yeah, this is actually something, one, that requires some expertise. So that should be an input to your PIA processes, on anonymization. But also just to highlight that anonymization is not a once and done thing either, that it requires a governance, because again, information, the usage changes within the organization, technology changes. This does require, just like AI, ongoing governance.
Right. Yeah.
So one of the key things to remember is in your PIA process, really what you've got to start thinking about, especially when you're now, as Carlos mentioned, introducing AI elements, it's not once and done. It doesn't go away. You have to build into this regular reviews so that you understand that what the risk of re-identification is a year from now, with changes in technology, with changes in what might be exposed in the world about those same data subjects.
Yeah, and I would say, don't know how, because you pointed out some really fine points in the law that you're the legal specialist, and we're not. Whether the you're doing only transfers, PIAs when data is transferred, but I actually when I work with my clients, I do make them do PIAs when introducing new technology, because I have no idea how they're introducing this technology, nor do they.
The obligation exists across the board. I think that the issue is whether you have to do the transfer assessment for employee data. But I'm going, what's the point? If you're going to be doing this, you're not going to think about these other sort of elements of risk. And you tend to follow the same approach because it's standardized. Let's just do it, and that way it's done. So, I mean, I do think that additionally, there's going to be some procedural challenges where we're going to, I think, end up. If you go to the next, I think we're almost at the point of concluding.
Yes, we are.
Is what do we want to say in general to get ready, right?
Yeah.
So I'll stop talking because I've been talking too much.
Well, I think Carlos, maybe you can pick up on this a little bit.
I just want to share a little bit of the different profiles we have seen in companies. I created like a list of categories. The first one is what I call the reactive. And the reactive is unfortunately the most common company. And these are the companies that do nothing until they face something. They experience a data breach, they are visited by the regulator, they have to respond to any request. And because of that, they start doing something. I think that's the worst posture you can take. And that means that you are not seeing value on trust generation. You're only thinking from a compliance perspective. There's another category that I have defined that I call the compliance. And these are ones that can be proactive, but the only vision they have is complying with the regulation. And they typically say, I want to do the bare minimum to comply with what the regulation is requesting. And again, I think that when you take that approach, you're not seeing value on what data protection and privacy is adding to the organization from the trust generation and preservation. There's another category that I identified as the technologists, which are the ones that want to resolve everything with tools. And although I see the value on tools, we need to think that tools need to work supported by processes. So if we have a process that is solid, that is clear, that is well thought, then you will be able to properly use tools. And something I want to say as well is that it is not all the time necessary to go outside running to buy a new tool. There's many existing tools that companies have that can be leveraged in order to respond to the many things they have to do for privacy considerations. They can have a ticketing system like ServiceNow, for example, that can be used to trigger DSARs and respond to them, or even trigger PIAs and properly work on them. Microsoft has different components that can help with data retention, data destruction, and stuff like that. So I think that the invitation here for those technologists is to identify what needs to be done, what tools they have in place so that they can identify what can be leveraged to make the best use of their money. The next category is what I call the analytical, which are the ones that spend a lot of time on making analysis on how personal information is processed. I see a lot of value on understanding that, but what we need to do is to avoid paralysis by analysis. So it's just a matter of finding the proper balance on these, to understand what we need to understand while we are acting at the same time.
And then do something, yeah.
Exactly, and the last ones are the ones I call the holistic, which are the ones that want to see the larger picture, to see how privacy is embedded into the risk management optics, which I think is a good approach. But I think that if you are very high level, you can lose visibility of the very specific things that you need to pay attention to on privacy. So from these multiple categories, I think that the only one I want to recommend people to stay away from is the reactive one. I think that's the worst one. Yeah. Unfortunately, that's very typical, but I think it's the worst one. And I think that from all the others, there's pieces we can take in order to be effective. We can have this larger picture, but we need to see the details. We can, of course, use technology, but we need to analyze how personal information is being used. And I think that if we have a combination of all of those, it can be useful for the organization. And I will stop there.
I really love that you categorize them. I think organizations really need to see which category they're in with honesty, and just say, okay, I think we need to move from that reactive stage to at least something, you know?
Yeah.
One thing we haven't talked about, and I'll invite Konstantin in a second, is about data retention, because I added data deletion here. But I have a little example to give you guys just as a trick. I've been working with a client and it's been impossible to take them through a proper PI, personal information data inventory exercise. It's been impossible. So what I've done is I turned the whole ask on its head, and I helped them write a data retention and deletion policy. And then I presented to them the government examples of the different records that could be produced in an organization. And I told them by group, please choose what records do you produce. And that gives us we're going backwards from there, but at least gives us some input from the business groups. And Konstantin, maybe something you can tell us about retention and that part.
Well, as Amalia, as you know, that's one of my favorite topics, because I see this perhaps one of the biggest areas of risk for Canadian organizations is that they never get rid of anything. And nobody wants to spend time and money on retention projects, because if anything, it could be less exciting to management and the business than privacy. It's got to be retention. So the problem is that 85% of any breach is data that no one should be holding any longer. And why our employees' data, when they've not been an employee for over 20 years, being exposed in breaches in Western Canada. This is actually happening real time. And there's really good questions as to why is that information still there?
Yeah.
It does multiply the size of a breach. It multiplies the consequence. And it also highlights you're not complying with your records management policy,
and
which is there for multiple reasons.
Yeah, exactly.
It's there for multiple reasons: litigation risk, information management risk. So I think that this is going to become one of the key areas, because we have unfortunately become pack rats when it comes to information. We keep it without knowing why. And I think a good question to turn back to your organization is always, when was the last time you actually pulled some data from this particular repository? If it was, you've never pulled anything more, older than 2 years, maybe that's a suggestion you should actually apply your records retention policy. We might need it later is not a valid basis for keeping data.
Yeah, it's not a legitimate interest. No, definitely.
Well, it's not defensible. And what it will highlight, and this has happened increasingly with the commissioners, with regulators around the world, is when a breach happens and they see that old data is there, then of course it just opens up a whole new area of inquiry that companies should not really be inviting.
Right.
So I'll leave that with that.
All right. Well, I'm going to switch to the last slide to say our thank yous. I think we could have talked for about at least another 6 hours, in my opinion. We just scratched the surface. Anyway, this was fun. It was an hour that went by in a minute. Thank you, Carlos. Thank you, Constantine. And thank you to our participants for asking questions.
Thank you, Amalia. There's one last question on sustainability. I just want to say to close this that privacy has become a topic that is included more often into ESG reports. Yes. There's a pretty interesting report from Forrester that is presenting how companies are using cybersecurity and privacy to be part of this in order to show sustainability. So thank you. Just wanted to say that, Amalia. Thank you so much for setting this up, and thank you all for coming.
Yeah, thank you. And if you find that report, share it, please, because that would be very, very interesting.
Yeah.
Read. All right. Well, thanks very much, everyone. Have a wonderful middle of the weekday, and hopefully we will see you soon.
Take care.
Okay, thanks, everyone. Bye. Take care. Bye.
Yeah.
Bye-bye.